Thank you, Sharon. Welcome, everyone. This is a great privilege for me and great interest to me as an administrative lawyer. Andrew Ferguson today, chairman of maybe our most important independent regulatory commission, certainly one of the great commission. It's also about the it's part of it. Yeah. And also Virginia. So wonderful. Welcome, Andrew.
Thank you for having me. Thanks to Salient for putting us on. Could you wear? Yeah. So, hi. We'll help the right. So what's here? I think it's on, but
it's not. Oh, there we go. Okay, now we're good. Thanks to the Salient for having me. I'm really excited to be here in Boston in February. A friend of mine told me, I got in late last night, and she said, make sure you bring a coat because the wind through Harvard Square is unbearable in February. She was right, I should have brought two. But I'm very happy to be here. Before we begin, I just want to say I'm chairman of the commission, but I'm here in my individual capacity. When I speak, I'm not speaking necessarily for the commission. But thanks for having me. Thanks for agreeing to do this.
Oh, sure. It's fun. And could we just start with a little bit of your backstory a bit before we get into the issues? Our people may not know about the partisan balance requirements on the commission and how it was that you were appointed by President Biden and elevated by President Kennedy.
That's right. I'm the most conservative Biden appointee probably for 4 years by far. So the commission dates back to 1914. It was it's sort of the second oldest, what we call independent in scare quotes, just for purpose of categorizing these agencies. The ICC was sort of the first version of this. They passed the FTC in 1940. They created the FTC in 1914 and then 1915, partly because of congressional dissatisfaction with the sort of vociferousness of DOJ's enforcement of antitrust laws. The Sherman Act and then the Clayton Act, which was passed a couple months after the FTC was created. And the FTC was sort of a creation or an experiment in agency creation. It was a multi-member board, which at the beginning of the 20th century was rare, but it had become a popular idea among progressive government types of the era to say we should have these, multi-member boards full of experts who can sort of craft policy, and most importantly, do it independently of the president. So they did two things with the FTC's office that were somewhat unique. The first was they required partisan balance. So there's a provision of our organic statute that says that no more than 3 of the 5 members can be members of the same party, 3 of the 5 commissioners, number one. And number two, there is a for-cause removal provision in the FTC Act. The law students in the room are probably familiar with a case called Humphrey's Executor against the United States. That arose when President Roosevelt attempted to terminate one of the Republican commissioners, not for cause, just because he believed, probably correctly. Humphrey is a super interesting guy. He was a Republican commissioner who used to say very openly that he wouldn't bring cases against companies owned by Republicans. He was quite open about this, and Roosevelt's view was probably unlikely he would implement my agenda, so he terminated him from the commission. Humphrey then sued for his paycheck. If you were wondering how a case like that comes up to the court, he sued for his paycheck. Then he died, so his estate brought the suit for his paycheck. And the court, in one of the most interesting admin cases, at least for what's left of it at this point, said that for agencies that do not exercise executive power and have quasi-legislative and quasi-judicial functions, legislative because we have the power to promulgate some rules, judicial because we also adjudicate disputes within our own internal court process. The president, the Congress can insulate members of such a commission or such an agency from presidential removal except for cause. That's in 1937, I think, 35 or 37. There's been a fair amount of development since 2010 on this front. It's hard to know exactly what is left of Humphrey's Executor, and we are probably going to find out soon. I have my own views on this, which we'll probably discuss, but President Trump has removed members of other subsequently created independent agencies by exerting what he says is Article 2 power, not for cause. One of those removed members of the National Labor Relations Board has now brought a suit challenging her removal. So it is, entirely possible that we will get sort of a square Humphrey's executor overrule question in front of the court, within a year, maybe less, depending on whether the court does what it has become very fond of doing, which is treating petitions for emergency relief as petitions for cert before judgment, and then deciding cases after a month of briefing. But that's the FTC. Our substantive authority is we enforce the antitrust laws, and we enforce consumer protection laws, except with regard to financial institutions and credit institutions, which belongs to the CFPB. That's sort of that's an overview of my agency.
Thank you so much. So I think it was very helpful for people, and we certainly will come back to Humphreys, although I fear we agree too much, as it were. Before we get into the administrative law, I just want to ask you in a general way. I know you can't comment on specific business or the commission, but in a general way, how would you describe your regulatory philosophy, and how would you sort of compare and contrast it with your rather visible and controversial predecessor in your office?
I'm gonna talk a little about that antitrust law, which has become very sexy over the last couple of years, which is weird as someone who's studying antitrust law. It was normally confined to like very small interest groups on the bar, and then every C-suite in America tended to care about antitrust. And it's become sort of a hot topic, actually because of the Trump administration, and I'll explain why very briefly. The antitrust laws go back to the late 19th century. They were, I'm simplifying here, so forgive me, but they were adopted as Congress responding to what were then called the trusts, but these were like gargantuan business associations that tended to wield pretty substantial monopoly power over huge parts of the economy, including commodities, oil, steel, etc. And Congress became of the view that these trusts wielded too much economic and political power, and that they needed to be confronted. So they created the Sherman Act in the 1890s, the Clayton Act in 1914, along with the FTC Act, and some changes since then. But basically, the substance of our antitrust laws are a law passed in the 1890s and two laws passed in 1914, and very few sort of statutory changes since. The laws are very capaciously worded. I mean, the two most important provisions of the Sherman Act, sections 1 and 2, it's like 50 total words that end up mattering. The Clayton Act, it's like 30 total words, which means that in many ways, the way that Congress set up the system is they passed sort of general principles of law. They were calling on a common law tradition, but not entirely. In fact, in the FTC Act, they very intentionally were trying to break away from the strictures of the common law tradition. And then they created executive branch agencies to enforce it. And when you are enforcing sort of capaciously worded laws, there tend to be a ton of discretion in how you enforce them, the priorities by which you enforce them, particularly when you have limited resources. All agencies' resources are limited. We do in fact print our own money, but there are limits to how much money one can successfully print. And so, enforcers have to make choices about when to enforce the laws, what the best targets are. For, I would say, the first 60, 70 years of antitrust enforcement, it was sort of all over the place. And part of the reason it was all over the place was that there was disagreement over what the purpose of the antitrust laws were above the very general level. So the purpose of the antitrust laws are to promote competition. Everyone agrees on that. Literally everyone that's ever done antitrust agrees with what I just said. There is massive disagreement on what it means to promote competition. And for a long time, there was disagreement over, does that mean we promote economic welfare? Whose economic welfare? Are we concerned about the political power of monopolies? Should we focus on combating politically powerful monopolies, even if they aren't particularly economically powerful? Should we focus on economically powerful monopolies, even if they're not wielding a lot of political power? By the 1960s and 1970s, it was actually kind of hard to define exactly what courts thought was the driving impulse of the antitrust laws. And then, most people are going to be familiar with this name, a brilliant professor at a law school not too far from here named Robert Bork writes a book called The Antitrust Paradox, a policy at war with itself.
You don't talk about the other place.
I didn't use his name. And the position he articulates is that all of the antitrust laws are motivated by one thing, which is promoting consumer welfare. His arguments are actually pretty complex, but the way that has been distilled over the years is that the antitrust laws focus only on prohibiting conduct or transactions that lead to either short or intermediate term increases in price or decreases in output. That is not actually what Professor, later Judge Bork, said in his book. He had a far more sophisticated view of this, but over the course of time, that's how it got distilled. This was an area of incredible bipartisan agreement. Democrats and Republicans, beginning in 1979, the Supreme Court cites Judge Bork's book, calls the antitrust laws statutes aimed at promoting consumer welfare, and we have what we call the antitrust revolution or the econometric revolution, which is the courts say, look, antitrust is about making sure that prices are low and output is high, and that is largely what we're going to focus on, and economists will tell us when that's going to be true. The reason that this works out this way is there are generally two types of antitrust cases. There's conduct cases. Those are cases where businesses are colluding behind your back to affect prices. And the other one is merger cases. And because of some changes to the laws in the 1970s, almost all merger cases require predictions. So you'll read about this in the Wall Street Journal, or at this point, almost any publication. Two big companies want to merge. They have to file a bunch of forms with the FTC and DOJ. Actually, the forms they're going to have to file are going to change beginning Monday to make it much easier for the agencies to sniff out anti-competitive deals. I'm very excited about that. But the agency then reviews these transactions and has to make a prediction about how likely it is that this transaction is going to substantially diminish competition or tend to create a monopoly. And the way that generally goes now is that you consult economists, they run some models, and they give predictions on price and output. This was the system basically until President Trump takes office. I don't know how many remember the 2016 election, but President Trump was on the campaign trail, first of all, talking about antitrust, which is very unusual for a presidential candidate. I was clerking for Justice Thomas at the time, having just finished practicing antitrust law, and was utterly fascinated by hearing a presidential candidate talk about it, number one. Number two, was talking about it in favor of bringing more antitrust cases than the Obama administration had been bringing. This is very unusual in Republican politics. Republicans tended to be very favorable, almost reflexively, to big business and the Chamber of Commerce. And hearing President Trump talk this way was, super fascinating. If you look at President Trump's record from his first term, it was really vigorous enforcement. Way more cases brought than the Obama administration, stricter enforcement in merger cases. They weren't proposing a change to the governing standard, but they were way more vigorous in when they were willing to enforce that standard. At the same time, on the left, the anti-monopoly movement or neo-Brandeisian movement has arisen. And the principal animating sort of purpose of that movement was the consumer welfare standard is actually wrong, and that courts have been misinterpreting the meaning of the major antitrust laws to focus on consumer welfare, and actually the antitrust laws protect more interests than just sort of short and intermediate economic welfare of consumers. They care about the sort of civic and democratic value of small businesses. They care about the political power that large aggregations of economic power are able to wield. And the focus on pure consumer welfare, the econometric version of consumer welfare, is short-sighted and inconsistent with congressional intent. These are upstarts on the left during the Trump administration. Then it gets really interesting. President Biden becomes president in 2021, and he appoints advocates of the neo-Brandeisian movement, Jonathan Cantor at the Department of Justice, Nina Khan at the FTC, as the principal antitrust enforcers. And then the game is really on, because we've gone from really unusually vigorous Republican antitrust enforcement to a Democratic version of antitrust enforcement that's actually calling for a complete reconsideration of the standard. And so the bipartisan consensus that had prevailed for 40 years, which is focus on price, output, short and intermediate term, is starting to collapse. Here is kind of generally how I feel about the state of affairs. I think that the Trump administration, the first Trump administration, and the Biden administration enforcers identified a real problem that we need to continue addressing, which is there was under-enforcement of the antitrust laws, not because of the insufficiency of the legal standards, but because of political choices about political economy and markets, and purely prescriptive normative views about markets. My view generally is the folks who favor very minimal antitrust enforcement and also urged us to think generally of consumer welfare as largely price and output driven, not to consider things like the risks to future competition, innovation, consumer choice, product quality. For anyone who's ever been censored on social media and think that these are like high quality products that are the result of vigorous competition, we should talk after because I really disagree. But things like that aren't just price and output driven, but still affect sort of consumers and their welfare. That I think was the great insight of the Trump administration, and Kahn and Cantor agreed. They also talked very unfavorably about consumer welfare. I'll talk about that in a minute. But my view is that they identified a real problem, which is that we had generally been too deferential to the C-suites and to the ideas that markets will always self-correct to address monopoly and non-competition. I just don't think that's true. And I don't think that's true theoretically, but I also think it's just proven not to be true. I don't, especially for people under the age of 40 like me, who have been living in America, I think it's hard to argue in light of the situation we confront with big tech that markets are always self-correcting. I think it's particularly hard to argue that after 2020. And my view is that the whole point of the antitrust laws is to just address the reality that markets are not self-correcting, they can't always defend themselves, and that decisions made in C-suites might be rational for the individual C-suite, but terrible for the economy. And I think there's another thing going on the right, which is super interesting, that's been very important to me in antitrust, which is there is a view among some who got a lot of power in the 90s, 2000s, and 2010s that markets are sort of an end unto themselves, and that sort of freedom, choices made in markets is the whole point of this. And I don't think that's right, and I know that my interlocutor here doesn't think that's right. The point of society, the point of political economy is human flourishing. And if we lose that perspective and we start to treat markets as the end, it becomes very hard to police markets, because if choices are being made in markets and markets are the end, why would we say, no, that's not a good choice? It was made by free people in a market, let it alone. And I think that the criticism of the right that is so persuasive is markets are a great way to allocate resources. They're a way better way to allocate scarce resources than a command economy. But that's not the end of government. It's just a resource allocation system. It's to promote human flourishing of every member of the society. And if markets aren't doing that, correction, regulation, et cetera, are a totally appropriate response. And so my view is, Lena Khan, Jonathan Cantor, critics on the right, identified a real problem, which was serious antitrust under-enforcement. I think in some cases over the last 4 years, the antitrust enforcers radically over-indexed for that problem. And that I think the goal is be very realistic about the problem, which is there were too much deference made to market actors because of views about markets, which are normative views, not just descriptive views, and that we should be more realistic about the shortcomings of markets and the goal of having markets in the first place, which is to promote human flourishing, and be very confident in our willingness for the government to intervene if markets are not promoting human flourishing. My view is the consumer welfare standard is a great way to help address human flourishing, but we can't just limit it to price and output. It has to sort of meet consumers where they are in all aspects of their participation in markets. And if market power is being used to make people worse off, not just consumers, workers, which is a super important focus of the last 4 years of the antitrust enforcers, the Biden administration, that I intend to continue, is aiming the antitrust laws to protect workers I think the goal here is to keep your eye on the ball, which is markets are great, they are not the end. Human flourishing is the end, and we need to be using antitrust as a mean to orient markets towards that end.
I think that's very well said. Thank you. And I want to break out a piece of it in the following way. So Ronald Coe said, there are markets and there are markets. There are markets for goods and markets for ideas. And I think there's a concern abroad in the land about the market for ideas being distorted in a certain way. That there are firms with a lot of market power that are pushing the market for ideas in certain directions with certain agendas. Can you comment on that a bit, especially in the social media content?
Yeah, that's a great question. So I heard this. Let me give a little background on how I sort of got to these views. So I graduated from UVA in 2012. I go and clerk on the DC circuit, and then I practiced antitrust for about a year and a half at a big law firm. Antitrust, I got into antitrust because it seemed like the least uninteresting thing I could do in big law. I ended up doing cases for the NFL. There's a lot of antitrust litigation, and that was genuinely interesting. I got to work on the Deflategate case when I was associated with Paul Clement. That was super interesting. But when I got into big law, it wasn't. I was like, I am all about antitrust. I just sort of scanned it's like insurance law or ERISA law, and I said, antitrust seems like the least horrible thing I could do, so I'm going to do that. But I rarely thought about the doctrine qua doctrine, because if you represent clients and you're working 3,000 hours a year, you think of the doctrine as just a tool to advocate for your client. My client has a problem. Here are the rules by which we solve the problem. Let me see what I can do within the rules to solve the problem. I went and clerked on the Supreme Court for Justice Thomas. We didn't really have that much antitrust stuff that term. We had a little, but that was the first time in my career that I got to sort of think about legal doctrines outside of just using them as a tool. I started to think about first principles. I had my own first principles, but they were normally the 14th Amendment does not protect a giant swath of unenumerated rights, including the right to abortion. The Second Amendment does protect an individual's right to keep and bear arms. All these things the courts were getting wrong. But for all sorts of doctrines, including private law doctrines or law in its intersection with the economy, I just hadn't thought that much about. It's just a thing I did in the law firm. Then I got to Hill. And then you have a lot of time and perspective to start thinking about these doctrines. And you get to see the rent-seeking. And that was very eye-opening to me. I had learned a story in law school that Lochner was not actually a case about protecting workers. It was giant bakeries trying to convince the state of New York to impose wage limits so that small immigrant bakeries would have to shut down because small immigrant bakeries needed to keep their employees working more than 8 hours a day in order to survive. The giant corporate bakeries didn't need that, and so they went to the state legislature and were like, hey, can you pass these worker welfare laws so that all our competition gets shut down? And I got on the Hill, I was like, oh my gosh, this is I have businesses coming up to me being like, you should pass this law that regulates my industry. And I would go, why? I learned in the Federal Society that regulation is bad. And they'd be like, well, bad regulation is bad, but good regulation is very good. And I started to get oh, right, barrier to entry regulation is very good. I understand what you mean. And then 2020 hits, and I'm just scanning, most of you all were, I think, adults in 2020. For me, 2020 was a baptism by fire, in particular, because as the George Floyd uprising is taking place, I have giant businesses and their trade groups calling me. I was Mitch McConnell's lawyer, so I was at the center of everything all the time, calling me and saying, hey, cops are racist. You guys should pass criminal justice reform. And I would go, why do you all care about this? Just sell your widgets. Why are you calling me about this? I thought this was the deal. We leave you free to sell your widgets, and you leave the political stuff to the people. Why do you care about this? And I started to say, oh my gosh, this deal that I was told we had, which is businesses will make their widgets and the government will leave them alone, and we will maximize innovation, and we shouldn't worry too much about big aggregations of private power, because all they want to do is make their widgets. It's just not true. It was just not true. I had GCs and big companies calling me and saying, hey, you should get rid of qualified immunity. And my response is, are you insane? Do you not see what is happening in the cities right now? Are you insane? And I started to then watch the censorship epidemic. COVID hits. You're not even allowed to say that COVID started in the COVID lab in Wuhan, China. You're not allowed to say, I don't think these masks that I can feel my breath coming in and out of the sides on work. You're not allowed to say, are we sure about this vaccine that you tested for 5 months? Are we sure it's safe? You're just not allowed to say it. If you say it, you're disappeared online. And I started to go, okay, that there is now a link that I understand in a way I just didn't get before between economic power and the deployment of that economic power to accomplish political ends. What I was told was, okay, fair, but the political ends are not the traditional concern of antitrust. And my response was, okay, I hear you, but isn't market power the traditional concern of antitrust? And if that market power reveals itself in the suppression of ideas because the economic power makes the suppression possible, isn't that the traditional concern of antitrust? And I was generally told no. My answer is yes. It unequivocally is. If your product is a speech platform,
Right.
and you're throwing people off of your product and denying people access to your product and denying other people access to the ideas on that product, product quality is supposed to be one of the facets of consumer welfare. That does not sound like a high quality product to me. And if you can get away with a low quality product and not suffer in the market, it's because there's a market power problem. And that, I think, is why antitrust cares about censorship. It's not because antitrust needs to police the ideas themselves. We can't. You trust me, you do not want me to be the converted censor. Well, you all might, but the rest of the country probably would not. But we should care about, if you care about human liberty as a means to achieve human flourishing, you should care about the deployment of private market power to suppress ideas that contribute to human flourishing. And yes, that isn't about price. Most of us are on X and Facebook, et cetera, for free, but it is an aspect of their product. It degrades the quality of that product, and antitrust does care about the use of market power to degrade the quality of that product. The other thing that I see in the marketplace that I think is a traditional concern of antitrust is the use of market power to dry up ideas indirectly. Elon Musk, in his capacity as the owner of X, has sued a bunch of giant advertisers and said, you all colluded to dry up advertising dollars on X. When I bought X and turned it into a free speech platform because you didn't want free speech. And there is a doctrine in antitrust that goes back many years that forbids concerted refusals to deal. In other words, you can't get in a room and be like, let's cut off this guy's business. That's like a core violation of the antitrust laws. Collusion is the core prohibition of the American antitrust laws. This is a classic example. And my view is, if that is in fact going on, and the purpose is to dry up capital and consumer access to platforms because they don't like the thing happening on that platform, this is the traditional concern of antitrust. To suppress market participation through market power because of the stuff coming out of that participant, this is a traditional concern of antitrust. So the short version of this is, I think that the only reason not to care about deploying the antitrust laws here, if there's in fact market power making censorship possible, is just because you're comfortable with the censorship. Censorship, the degradation of quality on these platforms is absolutely the traditional concern of antitrust. And if market power makes that possible, it cries out for intervention from the government.
Really. And another major issue that the FTC's been confronting is the so-called non-compete ban, as to which Chairman Ferguson wrote a really genuinely outstanding dissent. I urge the law students in the room to read it. It's not one I fully agree with, but it was just so well crafted that I recommend it. And I wonder if you could just say a little bit about that before we get to the really hardcore people straight. And not sure.
So a contract not to compete is quite literally what it sounds like. It's in the context we're talking about here, it's an agreement between an employee and an employer, where the employee says, after I leave your employment, I promise not to go to a place that competes with you, generally in some geographic radius for some discrete period of time. These agreements go back to the Middle Ages. The earliest cases in which English courts confronted these were the 15th century. As you can imagine, the law, quite appropriately, has generally looked pretty askance at these things. Originally, it was because in the 15th century, we're just coming out of the plagues of the High Middle Ages. There were lots of laborers with nothing to do because these populations had been devastated, and governments, both on the continent and in the Atlantic Isles, became of the view, hey, if we permit agreements where laborers aren't allowed to work, they're going to take the highway banditry, and that's already a problem, and this is going to make that problem worse, and so we're going to pass laws that forbid these sorts of things. Then by the 18th century, as the economy is getting a little more complex, people start to realize, hey, it's very difficult to sell a business or to buy a business if the purchaser of that business thinks that the business they're buying, the former owner, is going to immediately go found a competitor business. It makes the purchase of that business meaningless, and so courts started to be more favorable to these things. But as you can suspect, these agreements are rife with the possibility of abuse. There are examples of restaurants making line cooks sign non-compete agreements that say you won't go to a competing restaurant in a 100-mile radius for several years. That seems kind of silly. But you can see why these agreements might have some social utility. Imagine that you hire an engineer to learn some super specific, pretty secret business method in your firm, and it takes several years to train him or her. The last thing you want to do is to invest millions of dollars training that engineer, have that engineer walk out the door and take all your stuff to a competitor. If you aren't allowed to restrict the engineer's ability to do that, it just means that you'll never invest in the engineer. That's a real innovation problem. If you can't pass on knowledge within a firm, you can't innovate because you can't get smart people working on a problem, coming up with solutions, protecting those solutions. It just doesn't follow from the fact that these are sometimes, provide social utility. They always do. Every state regulates these. A couple states, including California, prohibit them. And more states are actually probably going to pass laws in the next couple months to prohibit them too. There had been a push in Congress for years to pass a law prohibiting non-compete agreements. It never quite got off, probably somewhat because of rent-seeking, but also a general view that states have been regulating this for a long time. There are lots of different ways to approach this. We should probably sort of let the laboratories of democracy, et cetera, do this sort of thing on our own. Then in 2024, the commission adopts a rule that more or less categorically bans non-competes everywhere in the country for everyone with a small carve out, everywhere, including the 30 million plus existing non-competes. The cost of this rule was about $500 billion, and was based on a statutory provision. The purported authority is a statutory provision that says that the commission shall have the power to categorize from time to time corporations and to pass other rules as necessary to carry out its functions. So there is a swirl of doctrines that Professor Vermeule can teach you about more learnedly than I can, that are in admin law right now. Non-delegation doctrine, which might be on its way back after a period of dormancy. The major question doctrine, which might be the non-delegation doctrine in disguise. It depends on which justice you ask. Justice Barrett says it's not. Justice Gorsuch says it is. The others tend to not pick a side, but it seems to do a fair amount of the work that non-delegation would otherwise be doing. And then there's the APA, which imposes all sorts of substantive and procedural restrictions on rulemaking. So this rule is adopted. I dissent. What I never do in my dissent, however, is extol the value of non-competes. I am of the view, first of all, that there are non-competes out there in the world that violate Section 1 of the Sherman Act. Section 1 of the Sherman Act forbids agreements and restraints of trade. An agreement not to compete is quite literally an agreement not to do the thing the Sherman Act requires us to do, which is to compete against each other. And as chairman, I absolutely intend to bring Section 1 cases in non-competes where the evidence shows that it actually diminishes competition.
Yeah.
The problem with the rule is that it was a blunderbuss approach to a problem that probably requires scalpel, which is every non-compete everywhere all the time is bad. It's just not true. It's just not true. And the rule even acknowledged that it's not true, but basically said it's a clearer line to draw to prohibit them all than to try to pick and choose. And I think that the problem with that is that Congress did pick and choose. our antitrust regime is not regulatory. There's not a bunch of ex-ante antitrust regulations. Europe has a lot of them. The United States has chosen not to. It's passed general laws and then given the executive lots of discretion about how to implement them, and has consistently resisted calls to do more ex-ante regulation or to give more ex-ante regulatory authority to the agencies. We have been sued for the non-compete rule, as I predicted in the dissent. The non-compete rule has been vacated nationwide, as I predicted in the dissent, and is sitting in the 5th and 11th circuits right now. My view is that the commission basically needs to decide whether it's a good idea. It's in the public interest to continue defending this rule. I've articulated my view on this rule. I think it's unconstitutional. I think it violated our Organic Act. I think it violated the EPA. I think that I'm going to be presenting at some point to my colleagues the decision about whether to continue defending this rule and spending all the money necessary to defend the rule. The Justice Department's having the same debates that we are right now. But I do want to be clear. There are non-competes out in the world that are violating the Sherman Act. I don't know where they are. I have zero doubt of it. It is really important to me that the Trump-Vance FTC continue taking antitrust enforcement in labor markets very seriously. I think that has gone wildly under-enforced basically for the entire existence of the antitrust laws. And I think that Cantor and Kahn got this impulse right, which is the antitrust laws protect workers, and we ought to use it to protect workers. So if there are non-competes out there, so the staff of the agency, if you find non-competes out there that are having anti-competitive effects by the Sherman Act, I want to do something about them. But I do not think that this rule is sustainable. And then Professor Vermeule has written extremely eloquently, sort of criticizing the non-delegation rule. My view on the non-delegation rule, very briefly, is this. If the point of all government is human flourishing, the question when we're allocating sort of like legislative power is which part of government is most likely to create rules of primary conduct that promote human flourishing. My own view, having spent time in Congress, state government, in the executive branch, and the judiciary, is that given the current state of our experts and our elites, the commons are more likely to produce values that promote human flourishing than elites are, and the commons are more likely to have their values reflected in decisions that Congress makes than in decisions that bureaucrats make. That is not necessarily eternally true, but that is my experience, is that self-government in 21st century America, where the people, the demos, have a more involvement in articulating their rules of conduct than separated elites, right now today is way more likely to produce rules consistent with human flourishing than our woke elites are. And that is why I am more comfortable, I think, than Professor Vermeule on the idea of revivification of non-delegation, because my experience is Congress answerable to the average American is way more likely to produce rules that promote human flourishing than bureaucrats ensconced in agencies who have no idea what the average American thinks and are basically just the intellectual and ideological colleagues of the professional managerial class that have gotten us in this situation, first instance.
Gotcha, understood. I think that's a totally coherent view. We only have a couple minutes now before lunch, but I did want to ask you about the putative independence of subordinate executive officials. This has come up in two ways. Actually, one is the president discharging members of regulatory commissions like the MLRB. The other way it's come up is with respect to so-called administrative law judges within agencies, as to which the chairman also Roman Carcashen. Do you see these as the same problem, or what is your general philosophy about independence as or to executive?
So we have a civilian government of like 2 to 3 million employees and officials. If you knew that when you voted for president, you were voting to give the president power over like a couple hundred, direct power over a couple hundred of those, would you care particularly about the election? I wouldn't. Like if I knew that every time we voted for president, we were basically voting for the like spokesman in chief of a government that ran itself day to day, I'd be like, oh, why are we spending $4 billion in this election? Because it really mattered that much. The reason we care about the presidential election is because we all think we're picking the man who's going to be sitting atop that government and telling it what to do. And the independence, so first of all, on independence, it's super interesting because for a lot of these agencies like mine, the idea of independence is like an important part of its culture, but it really just emanates from like a couple statutes that provide for-cause protections for the commissioners or the members, and then Humphrey's executor, which kept calling them independent. But like, there's nothing in our law that says that like they must be independent from presidential control. They should not talk to the president. They should not consult with the president. It's just these removal provisions. So we've built up a structure around these removal provisions that actually is not directly related to the removal provisions. Number one. Number two, this relates back to my view that the part of our society right now most likely to produce rules of conduct that are consistent with human flourishing is just the commons and not the elites. Is if we elect the president, so the president is answerable to the people, but then people below him are not answerable to him, we cut off the people from their government. And that's just not self-government. It's just government by government, and we are the governed. But we basically are not meaningfully participating in our own self-government. And look, like, you know, the founders were geniuses. I think sometimes they got it really right, sometimes they got it wrong. But I think the one thing they got wrong, and Madison articulated it very beautifully during the debate on removal in 1789 in Congress, is the Constitution sets up a chain of independence from the commons directly to the meanest official, lowest official federal government through the president. The people, through their legislatures at the time, but the people select the president through the traditional electoral college. People select the president, and then the president is in charge of subordinate executive officials. And if that isn't true, then we aren't in charge of our government. And there really is a deep state that just governs for itself in its own interests, totally unrelated to the interests of the commons. Now look, this might be a less pressing catastrophe if the elites in charge of government sort of had the interests of the commons and human flourishing in mind. My experience is the FTC is full of really good lawyers who do care about human flourishing and do actually want to obey the law and do the right thing. But the federal government is full of people who don't. Just read the stuff that USAID was spending money on. I mean, God help us all. And if the president can't direct these agencies, we can't. And then there's nothing we can do about it. If the president can't direct them, and look, the Chief Justice in Free Enterprise Fund, which is the first removal case in 2010 that really took this question super seriously, said if the president doesn't have removal power, he's reduced to the cajoler-in-chief. And if the only thing he's allowed to do is to convince subordinate officials to carry out his will, which is supposed to be the will of the people since we put him there, the government is we are not in charge of the government is in charge of us. That is a bad situation under normal circumstances, a terrifying situation under present circumstances. I think presidential control over the entirety of the government, from the meanest official, as James Madison put it, to the highest, is indispensable to self-government, and self-government in this society is indispensable to human flourishing. This is why I care about this so much.
Here, thank you very much for that.